Welcome to Unlocking American History podcast, where we delve deep into the stories and significance of pivotal moments in the nation's past. The Unlocking American History podcast is produced by Histon News and Sean Young. Here is your host.
I'm your host, John Mills, and welcome to Unlocking American History, where we delve deep into the stories and significance of pivotal moments in the nation's past. In today's episode, we'll explore a lesser-known yet fascinating aspect of the 14th Amendment, Section 3. Join us as we unravel the complexities and controversies surrounding this crucial piece of legislation. Today, we dive into the context of Section 3 of the 14th Amendment. In recent history, the Colorado court voted 4-3 in December to disqualify Mr. Trump under Section 3 of the post-Civil War 14th Amendment, also known as the Insurrection Clause. The four justices held that Mr. Trump engaged in an insurrection or rebellion on January 6, 2021, based largely on evidence from the House January 6 Special Committee. Maine's Secretary of State has made a similar ruling, though several other states have ruled in Mr. Trump's favor on the question. The Colorado court voted 4-3 in December to disqualify Mr. Trump under Section 3 of the post-Civil War 14th Amendment, also known as the Insurrection Clause. The four justices held that Mr. Trump engaged in an insurrection or rebellion on January 6, 2021, based largely on evidence from the House January 6 Special Committee. Maine's Secretary of State has made a similar ruling, though several other states have ruled in Mr. Trump's favor on the question. The 14th Amendment includes the following. Citizenship grants citizenship to all people, born or naturalized in the United States, including formerly enslaved people. Equal protection provides all citizens with equal protection under the laws. Due process guarantees procedural due process, meaning that government actors must follow certain procedures before they may deprive a person of a protected life, liberty, or property interest. The Apportionment Clause gives the federal government the ability to punish states if they unconstitutionally limit the right to vote. Disqualification Clause bans those who engaged in insurrection from holding public office. Right to privacy. The Supreme Court has broadly read the liberty guarantee of the 14th Amendment to guarantee a fairly broad right to privacy. Today, we will study Section 3 of the 14th to learn more about the text and reasoning for this section. The text of Section 3 is the following. Disqualification from office for insurrection or rebellion. Here is what Section 3 says. No person shall be a senator or representative in Congress or elector of president and vice president or hold any office, civil or military, under the United States or under any state who, having previously taken an oath as a member of Congress or as an officer of the United States or as a member of any state legislature or as an executive or judicial officer of any state to support the Constitution of the United States shall have engaged in insurrection or rebellion against the same or given aid or comfort to the enemies thereof. But Congress may, by a vote of 2/3 of each house, remove such disability. Soon after losing the Civil War in 1865, states that had been part of the Confederacy began to send unrepentant former Confederates, such as the Confederacy's former Vice President, Alexander H. Stephens, to Washington as senators and representatives. Congress refused to seat them and drafted Section 3 to perpetuate, as a constitutional imperative, that anyone who violates their oath to the Constitution is to be barred from public office. Section 3 disqualifies from federal or state office anyone who, having taken an oath as a public official to support the Constitution, subsequently has engaged in insurrection or rebellion against the United States or given aid or comfort to its enemies. Southerners strongly opposed it, arguing it would hurt the reunification of the country. 3's role in barring individuals from holding public office if they had previously engaged in rebellion or insurrection against the United States. The intent behind this provision was to prevent former Confederates from regaining power and influence in the government. Section 3 does not specify how it is to be invoked, but Section 5 says Congress has enforcement power. Accordingly, Congress enforced Section 3 by enacting Sections 14 and 15 of the Enforcement Act of 1870, the pertinent portion of which was repealed in 1948. There is still a current federal statute, 18 U.S.C. SS 2383, that was initially part of the Confiscation Act of 1862 and revised in 1948, disqualifying insurrectionists from any federal office. Moreover, each House of Congress can expel or exclude members for insurrection or other reasons, although it is uncertain whether more votes may be required to expel than to exclude. A further way that Congress can enforce Section 3 is via impeachment, and even before the adoption of the 14th Amendment, Congress impeached and disqualified federal Judge West Humphreys for insurrection. After the amendment's adoption in 1868, disqualification was seldom enforced in the South. At the urging of President Ulysses S. Grant, Congress passed the Amnesty Act in 1872, which removed the disqualification from all but the most senior Confederates. In 1898, as a gesture of national unity during the Spanish-American War, Congress passed another law broadening the amnesty. Congress posthumously lifted the disqualifications of Confederate General Robert E. Lee in 1975 and Confederate President Jefferson Davis in 1978. These waivers do not bar Section 3 from being used today. Between Reconstruction and 2021, Section 3 was invoked only once. It was used to block Socialist Party of America member Victor L. Berger of Wisconsin, convicted of violating the Espionage Act for opposing U.S. entry into World War I, from assuming his seat in the House of Representatives in 1919 and 1920. Berger's conviction was overturned by the Supreme Court in Berger v. United States, 1921, after which he was elected to 3 successive terms in the 1920s. He was seated for all 3 terms. On January 10, 2021, Nancy Pelosi, the Speaker of the House, formally requested representatives' input as to whether to pursue Section 3, disqualification of outgoing President Donald Trump because of his role in the January 6th United States Capitol attack. On January 11, 2021, Representative Cori Bush, DMO, and 47 co-sponsors introduced a resolution calling for the expulsion, under Section 3, of members of Congress who voted against certifying the results of the 2020 U.S. presidential election or inciting the January 6th riot. Those named in the resolution included Republican Representatives Mo Brooks of Alabama and Louis Gohmert of Texas, who took part in the rally that preceded the riot, and Republican Senators Josh Hawley of Missouri and Ted Cruz of Texas, who objected to counting electoral votes to certify the 2020 presidential election result. In January 2022, after Representative Madison Cawthorn, RNC, declared his intent to run for re-election, a group of North Carolina voters from Cawthorn's district filed suit, alleging that a speech he gave immediately before the Capitol attack incited it, and that therefore Section 3 disqualified him from holding federal office. A federal judge entered a preliminary injunction in favor of Cawthorn, citing the Amnesty Act of 1872. However, on May 24, 2022, an appeals court ruled that this law applied only to people who committed constitutionally wrongful acts before 1872. A similar challenge, which a federal court declined to block, was filed in March 2022 against Marjorie Taylor Greene, RGA, and heard in April 2022 in Atlanta. A Georgia administrative law judge ruled that Greene was eligible to appear on the 2022 Republican primary ballot in Georgia, and Secretary of State Brad Raffensperger and the Fulton County Superior Court affirmed this. Though Greene sued to strike down the state law as unconstitutional, a federal court said her complaint was moot since this law ultimately did not deny her eligibility for re-election. Couy Griffin, an Otero County, New Mexico commissioner, was barred from holding public office for life in September 2022 by District Court Judge Francis Matthew, who found his participation as the leader of the Cowboys for Trump group during the attack on the Capitol was an act of insurrection under Section 3. On January 2, 2024, a lawsuit seeking to bar Scott Perry, RPA, from the 2024 ballot via Section 3 was filed. On January 5, 2024, a lawsuit seeking to disqualify Burt Jones from holding office as Lieutenant Governor of Georgia via Section 3 was dismissed. By October 30, 2023, lawsuits seeking to disqualify Trump from the ballot under Section 3 of the 14th Amendment via state courts had also been filed. Some legal scholars speculated that a court would be required to make a final determination that Trump was disqualified under Section 3. The United States Supreme Court has never ruled on the meaning or application of the insurrection clause. Legal experts expected at least one of these state cases to be appealed to the U.S. Supreme Court. On December 19, 2023, in the case Anderson v. Griswold, the Colorado Supreme Court held that Trump was disqualified from holding the office of president under Section 3 of the 14th Amendment. Furthermore, the court held it would be a wrongful act under the election code for the Colorado Secretary of State to list Trump as a candidate on the presidential primary ballot. This decision was stayed until January 4, 2024, in the expectation that Trump would seek certiorari from the United States Supreme Court. The Colorado Republican Party appealed the case to the U.S. Supreme Court, and the Colorado Secretary of State announced that Trump would be included on the primary ballot unless the U.S. Supreme Court declines to take the case or otherwise affirms the Colorado Supreme Court ruling. On December 28, 2023, Maine announced that Trump would not appear on the ballot when the Secretary of State decided that Trump had committed insurrection, Although the ruling was stayed for judicial review, Trump appealed to the Kennebec County Superior Court. On January 17th, the case was remanded back to the Maine Secretary of State for reconsideration after the U.S. Supreme Court ruled on the Colorado case. On January 3, 2024, Trump appealed to the U.S. Supreme Court on the Colorado matter. His attorneys argued that Section 3 of the 14th Amendment should not apply to the presidency because the president is not an officer of the United States. The Supreme Court announced on January 5, 2024, that it would hear the Colorado case, scheduling oral arguments for February 8th. On January 30th, 2024, a challenge that cited Section 3 to argue against the inclusion of Biden on the Illinois Democratic primary ballot was dismissed by the Illinois State Board of Elections. As we conclude today's episode, it's clear that Section 3 of the 14th Amendment remains a fascinating yet often overlooked aspect of American history. Its impact on post-Civil War politics and its enduring relevance today highlight the complexities of reconciliation and reconstruction in the aftermath of conflict. Thank you for joining us on this journey through history. Stay tuned for our special episodes of Unlocking American History, where we cover the entire full oral 14th Amendment. Section 3 arguments before the United States Supreme Court. Docket number 23, 7, and 19, Trump v. Anderson. Today's topic sources: National Constitution Center, ND. 14th Amendment, PBS, 2003. The 14th Amendment and Section 3, debated, litigated, and misinterpreted. Wikipedia, org/wiki, 14th Amendment to the United States Constitution.
Thank you for joining us on this journey through history. Tell your family and friends to subscribe for more episodes of the Unlocking American History podcast, where we continue to explore the key moments and individuals that have shaped the nation we know today. The Unlocking American History podcast is produced by Histon News and Sean Young. Thank you for listening.